My name's Kate Redshaw, and I'm a senior lawyer in the employment team at Burgess Salmon. And I'm delighted to be joined today by one of our employment lawyers, Hugh Cook. And Hugh's a very talented individual because not only is he an employment lawyer, he is also a business immigration specialist. And Hugh, we've got lots to cover today because I want to talk about Brexit and what that means for employers who use EEA nationals and also other nationals from overseas because the system is changing. So in particular, I'd like to look at the position currently for employers who employ EEA nationals. Then I'd like to look more broadly at how the immigration system is changing. And then, because I know you love a top tip, Hugh, I'm going to let you, if you're happy to do so, to share some of your top tips for employers as to what they can be doing now to prepare for these changes. So Hugh, looking first then, what is the position for employers who are currently employing EEA nationals who are living in the UK? What, if anything, do those people need to do?
Morning, Kate. Well, what a treat you've got lined up for me. I mean, for the EEA nationals, anyone who is here by the 31st of December this year can stay until the end of June 2021 and not need to do anything. The issue, I think, is that if they want to stay beyond that date, they need to apply under the government's EU settlement scheme. That scheme's free. They use an app online to do it, pretty straightforward for the vast majority of people, and that will give EEA nationals who are here by the end of this year and their family members the right to then stay in the UK. Only applies in respect to people who arrived before the 31st of December. For EEA nationals arriving from the 1st of January onwards, you're into the new immigration regime, which I think we're going to talk about.
Okay, so there's a window at the moment for employers to bring over, and I know it's difficult times at the moment, but there is a window for employers to bring over EEA nationals now before 31st December for them to apply, as you've talked about, via the app, and that will be that for that category of people. But I'd like to look at what happens after 31st December for EEA nationals, because they're going to be treated like any other overseas nationals, I think, at that point. But before we go on to do that, could you just cover off the position with Irish nationals, which I think is a little bit different?
Yep, Irish nationals is pretty straightforward because Irish nationals have the right to live and work in the UK under legislation that predates our entry into Europe, and so Brexit doesn't affect it. Put simply, Irish nationals can continue to live and work here and use their passport as evidence of that, so pretty straightforward.
Okay, so on the basis that lots of employers right now are not going to be in a position to bring over a host of people before the 31st of December, let's have a look at what the system is doing after that date. I know that a white paper has been issued, which has given a lot of detail about how the new immigration system will work, but it's not dotted all the I's and crossed all the T's, so we are still awaiting, at the time we're recording this, further information and detail about the system. But what can you tell us just as an overarching view at the moment, Hugh?
Yeah, so broadly speaking, what we're going to have is an immigration system that applies to everyone other than UK and Irish nationals. So any overseas national wanting to come to the UK will need to have permission under the new regime. That said, it's a pretty complex regime with lots of ways in which individuals might have the right to work in the UK. Students, for example, can work as part of studying. You may have individuals who have the right because of Commonwealth ancestry, because they're married to British nationals and so on. But I think in the employment context, we're really talking about Tier 2 of the points-based system being the main focus.
Okay, yes, so Tier 2. Now, at the moment, a lot of employers who only use EEA nationals and don't have other employees from overseas won't be familiar with Tier 2, and nor, I suspect, will they be familiar with the fact that in order to get a Tier 2 visa, you have to have a sponsor's licence. So before we go on to look in more detail about that two-tier visa route and what's changing there, can you talk to us a little bit, Hugh, about sponsors' licences and what they're all about?
Yeah, so I mean, a sponsor's licence really is permission from the Home Office for a UK employer to employ an overseas national in a specific role. And sponsors license have two elements to it, I think. Firstly, you've got to demonstrate you're a genuine UK business with a trading presence so that the government has confidence that you are who you say you are and that you'll police the immigration system. And that's an application which you do with various documents to prove you exist. The other important element, I think, is the continuing one, which is as a sponsor, you are under duties to ensure compliance with the immigration regime. And that does mean that an employer needs to put in place procedures, policies, train up staff to ensure that ongoing compliance. So there are two elements there, but as a starting point for someone who hasn't got a sponsor's license, they'll need to apply. The current statistics suggest that it's just under 8 weeks processing time for a sponsor's license application, but that can be longer. If you're in a high risk sector, such as hospitality and retail, you may get a visit from the Home Office to check. Or we may find at the end of this year there's a sudden rush as businesses realise they do need a sponsor's licence for 2021. So I think if you do need one, get your application in as soon as you can.
Yeah, that's good advice. And it's useful to know it's not just getting the piece of paper. It's also about doing all the, you've got all the other obligations and duties that you've just outlined that you'll need to have processes for to support. So I've got my shiny license though. I'm ready to go. Tier 2, I think, is what we've said is the route a lot of employers will use, and there are two routes on that particular visa process, aren't there? There's the intra-company transfer, and then there's the route that's currently called the Tier 2 general visa. Hugh, I think the intra-company transfer route isn't changing all that much. So do you want to just tell us a little bit about that, and then we'll move on to the general visa?
Yeah, I mean, the intracompany transfer route allows a temporary transfer of staff between group companies between different countries. So you might move someone from an Australian group company into the UK for a temporary period of time. It's for high skilled workers only. There's no requirement for a specific level of English. And frankly, it's for pretty well paid roles within that. So that isn't changing. What I think will be relevant is that if you're a UK sponsor and you want to transfer staff from an overseas group company, you've got to ensure that your sponsor's license links that overseas company, and you need to do that by demonstrating to the Home Office through relevant documentation that they are group companies. So something both for existing sponsors and new sponsors to think about.
Okay, no, that's useful. And then looking at the Tier 2, as it's called at the moment, general visa. Now that allows employers to bring over overseas nationals from outside the EEA who aren't working in the same corporate structure. But it's quite a challenging test at the moment, isn't it? I know there's the resident labour market test, which means that employers have to show before they can get that visa, they have to show that there is nobody in the UK or the EEA who's able to do that role, and also that requires advertising, which I know brings with it difficulties. There's a minimum threshold for salary. So how is that route changing? Because obviously that's going to be one that employers are going to need to be very familiar with, because of course all the EEA nationals are going to come within it as well post 31st December.
Yeah, I mean, you're right. I think that the first piece is the change in name. We won't have Tier 2 General anymore. We will have Tier 2 Skilled Worker. But that said, it's still fundamentally the same process. You've got to have a UK sponsor and an individual from overseas who has a job offer from that sponsor, that the job is suitably skilled, that it's paid at the prescribed amount, and that the individual speaks a particular level of English. That all remains the same, but there are some useful changes. Firstly, the skill level for the role is coming down. Currently, it's degree level or higher, but going forward, we're going to see that drop to A level qualification or higher. So that will open it up to a wider range of roles. We're also going to see the salary threshold reduced from about 30,000 typically to just over 25,500. There are some exemptions around that, but again, that drop will also open it up to a wider range of roles. We're going to see the cap removed. At the moment, there's a limit per month on a number of Tier 2 general visas that can be issued. And if you fall foul of that, you find yourself waiting another month to recruit. So that delay will go, which is good news for employers. And finally, as you mentioned, the resident labour market test, that's been the bane of many sponsors' lives. It's very prescriptive and things do go wrong. The removal of that's going to be very helpful, but I don't think it removes that underlying issue of you've got to have a genuine vacancy. And I think that's where the Home Office will want to see employers really focusing.
Okay, that's helpful to know, and it's interesting that those thresholds are actually coming down. As you've talked about the salary threshold coming down and the requirement for A level rather than degree and so on. But just looking at that salary threshold, I think you mentioned it's 25,600. Where does that leave our low-skilled workers? Because that threshold, albeit lower, is still pretty high.
Yeah, I think it leaves employers in a very difficult place for low-skilled or low-paid roles. The government have said they're not going to have an immigration route to cover that, and therefore employers are left with some difficult choices. Can they rely on EEA nationals who were here and have applied under the EU settlement scheme? Can they recruit from the local UK workforce or Irish nationals? Can students cover anything? I think it's going to be very difficult. We're seeing some push for sector-specific schemes, so agricultural schemes to harvest crops. We're seeing health and care sector schemes being opened up, so we may see some of those. But employers are going to face a very difficult situation in terms of how they staff, and they may need to think about automating processes or even offshoring work. So some analysis and difficult decisions, I think, in that situation.
Yeah, no, I can see that. Okay, so just before we close, and we've covered a lot of ground already, thank you for that, Hugh. But drum roll, please. It's time for Hugh Cook's top tips for employers on what to do now to get ready for the new immigration system.
Well, after an introduction like that, what more can I do, Kate?
I hope they're good.
Well, I mean, we've got more detail coming, but there are things you can definitely do now, and I think those are as follows. Firstly, if you haven't already done so, remind your EEA nationals that they do need to apply under the EU settlement scheme to protect their rights. It's not automatic protection. Secondly, ensure your right to work processes are really bulletproof, because you're going to have a wider range of employees who need to demonstrate immigration permission when we get into 2021. Thirdly, you're going to have to look closely about your workforce planning. It's going to take longer, it's going to be more costly, and it's going to be more resource heavy to sponsor individuals. For example, even under the new scheme, a skilled worker who you want to put on a 5-year visa could cost up to £9,000. Comparing that to zero cost right now, that's going to have massive implications for businesses. So they're going to need to look at that. If you've done that and you decide you do need a sponsor's license, get your application in as soon as possible. And then finally, I think it's the old classic of you've got to train the staff, you've got to have internal resources allocated, and you've got to have the procedures and processes there to ensure that you can meet the duties that you're going to have going forward.
Hugh, thank you so much. That was really useful. Lots of things for people to be actioning now. If you need any advice or help about what you've heard today on sponsor licenses or how the new Tier 2 system will work, please do get in touch with Hugh or any other member of the business immigration team here at Burgess Salmon. There's also a guidance note which you might find useful, which is on our Burgess Salmon website, which tells you about the new system and how that's going to work to the extent that we know so far. So plenty for you to look at there as well. That's it from us today, but thank you very much for watching. Goodbye.